Friends, I welcome you all to practice series in the Clat lecture series. This is lecture number 3. These classes are sponsored by Sri Jendra Rank Zone. I am your mentor Shekhar Gehlot. So now you all understand the principles on which we are working, how these questions have to be answered. So these are test questions. So let us proceed with the question for today. The principles are in this question. Consumable goods which are not fit for consumption are not marketable. One thing. A consumer shall not suffer on the account of unmarketable goods. 2. A seller is liable for knowingly selling unmarketable goods. Knowingly selling unmarketable goods. 3. A manufacturer shall be liable for the quality of his product. Now, seller is liable for selling unmarketable goods, knowingly selling unmarketable goods, and a manufacturer is liable for quality for his goods. Okay. Now let us read the principal facts. Ram bought a Coca-Cola bottle from Shama's shop. Back at home, the server opened the bottle and poured the drink into the glass of Ram and his friend Tom. As Tom started drinking, he felt irritation in his throat. Immediately, Ram and Tom took the sample for test and found nitric acid in the content. Ram filed a suit against Shama, Coca-Cola Company, and the bottle, Kishan and Company, and the bottler, Kishan and Company. So there are three parties. One who has sold, it is the seller. Drink belongs to Coca-Cola Company, and the bottler who has packaged the bottle, Kishan and Company. Now, suggested decisions. Now, what could be the decision? Ram cannot get compensation. Tom can get compensation. Okay, Tom can get compensation. Both Ram and Tom can get compensation. So first of all, we have to look into this. What should be the right answer? Ram cannot get compensation, but consumer should not suffer on account of unmarketable goods. So Ram is definitely a consumer. So is Tom also a consumer because Ram purchased it? Okay, but when Ram purchased it, he served it to the Tom. So Tom automatically also becomes a consumer. So now both Ram and Tom can get compensation. Okay, because consumer is not only one who purchases it, but definitely the one who ultimately consumes it. Suppose my father purchases something, like suppose an air conditioner, and it is not functioning properly. So does that mean I cannot file a case? Yes, I can also file a case. Why? Because I need not be a direct purchaser of the product. I am the beneficiary. My father has purchased something for the family. I'm a part of the family. We all become beneficiaries. So we are also consumers. You don't become consumer merely by purchasing something. We can become consumer if we are the beneficiary or user of that particular thing. So here, both Ram and Tom can get compensation. First is C is okay. Now let us go to suggested reasons. Shama did not know the contents of the sealed bottle. Okay. Ram did not actually suffer though he bought the bottle. Now we have decided this answer. Now why this answer is suitable? Let us see. Ram did not actually suffer though he bought the bottle. No. Ram is consumer. He suffered. Tom did not buy the bottle. No. Coca-Cola company is responsible since it supplied the concentrate. Okay, it supplied the concentrate, and it is found that nitric acid was high. So definitely, somewhere Coca-Cola company is responsible. But let us see the other options as well. Kitchen and Company is responsible since it added water, sugar, etc. and sealed the bottle. Now this is a very key thing. Sealed the bottle. Who ultimately sealed the bottle? Kitchen and Company. Shama is responsible for selling the defective product. Can Shama be responsible for selling a drink which has higher nitric acid? Definitely, let us see. A seller is liable for knowingly selling. So how can Shama know that nitric acid is more in this particular bottle? Shama cannot know this. Okay, so Shama is out of the picture. Now both can get the compensation. Now from whom will they get the compensation? Coca-Cola company or the Kishan and company? Now Coca-Cola has supplied just the concentrate. Okay, so concentrate, and Kishan and company has added water, sugar, and sealed the bottle. So when Kishan company added water, they should have added more water, or they should have done something before. They should have checked the concentrate. Okay, the ultimate responsibility in these kind of products lies with the one who is finally sealing the bottle. So Kishan and company has sealed the bottle. So now the ultimate responsibility lies with the Kishan and company. They should have checked the quality. So now C and 5 should be the option. Let us see. A, B is C and 5. So C and 5 is option C. So option C is the correct answer here. Now I hope you are understanding the reasoning for this. See, I'm not writing all the principles or the reasoning which I'm telling you right now. I'm just telling you the answer and I'm verbally telling the reasoning, because if I start writing reasoning in the comment section, it would ultimately take a lot of time. So we cannot spend this much time in these test exercises. So I'll just talk on and you can listen to it and then you can check it with the answer. 44. If A asked to do something, okay, if A asked to do something by B, B is responsible for the act, not A. Okay, so if A, while acting for B, commits a wrong, A is responsible for the wrong, not B. These are the principles. If A is authorized to do something for B, but in the name of A without disclosing B's presence, both A and B may be held liable. Okay. Facts. Somo contracted with Amar, whereunder Amar would buy a pump set. Now, Somo contracted with Amar, okay, whereunder Amar would buy a pump set to be used in Somu's farm. Such a pump set was in short supply in the market. Gulab, a dealer, had such a pump set and he refused to sell it to Amar. Now, he refused to sell it to Amar. Okay, Gulab refused to sell it to Amar. Amar threatened Gulab of serious consequences if he fails to part with the pump set. Now he failed. He refused to sell it to Amar. Maybe any reason. He is the owner. He can refuse. Okay. But now Amar threatened Gulab with serious consequences. Now Amar is committing a crime. Okay. Gulab filed a complaint against Amar. Now let us see who all will be liable. Amar alone is liable for the wrong, though he acted for Somu. Amar is not liable for wrong. Now in this case, what is happening? Third principle is applicable. If A is authorized to do something for B, but in the name of A without disclosing B's presence. Okay. That means A is doing something for B, but he is doing it in his own name. He is not telling it that I am doing it for B, but ultimately A is doing it for B. Okay, but he is doing. Okay, so in this case, Amar is doing it for Somu, but Amar is doing it in his name. So we'll look at third principle now. Amar alone is liable for the wrong that he acted for Somu. Amar is not liable for the wrong, though he is bound by the contract with Somu. Somu is bound by the contract and liable for the wrong. Both Somu and Amar are liable for the wrong. Okay. So now, in this case, we'll have to see what will happen. Amar committed the wrong while acting for benefit of Somu. Amar cannot do while acting for Somu something which he cannot do while acting for himself. Both Amar and Somu are liable. Somu has to be responsible for the act committed for Somu's benefit. Okay. Now let us see the principle 2. If A, while acting for B, commits a wrong, A is responsible for the wrong, not B. Okay. Now what he has done, Amar has committed a wrong here. This wrong is not a civil wrong, that he has committed some negligence or omission, that both would be liable. Amar has committed a crime. So when Amar is committing a crime, now principle 2 will come into picture. If A, while acting for B, commits a wrong, now A is acting for B, but A commits a wrong. A is responsible for the wrong, not B. Okay, so let us see the options now. Amar has committed a wrong, so Amar should only alone be liable because principle B is applicable. Now let us see which option makes only Amar liable. Amar alone is liable for the wrong, though he acted for Somu. Okay, now option A is okay from here. Now suggested reason. Amar committed the wrong while he acted for the benefit of Somu. This cannot be the reason. Amar cannot do while acting for Somu something which he cannot do while acting for himself. Both Amar and Somu are liable. Out of the picture. Somu is responsible. Out of the picture. Okay, so now we have to find only within these two whether Amar is liable because he acted for the benefit of Somu, or Amar is liable because he cannot do something while acting for Somu which he cannot do for himself. So committing a crime, Amar cannot commit a crime whether he is acting for himself or whether he is acting for a Somu or some other person. So now here options are like A1, A2, D and 4. What is the reasoning? Our reasoning is Amar alone is liable plus Amar cannot do while A and 2. So our answer is B. Okay, our answer is B. If we go with option D, what is option D? Both Somu and Amar are liable. This is out of the picture. Okay, if we go with 4, only 4. Somu has responsible. Somu cannot be made responsible. This is again out of the picture. If we look at A, so now Amar committed the wrong while acting for benefit of Somu. Now this may look appropriate, but this is also a wrong answer because a crime is a crime. Okay, you cannot commit a crime while acting for someone else or not. You commit a crime in your individual capacity always and always. Other person shall not be liable for your crime unless and until he becomes a party to the crime. He instigated you or he asked you to commit that crime. Okay, so this principle is applicable here. 45. An employer shall be liable for the wrongs committed by his employees in the course of employment. Third parties must exercise reasonable care to find out whether a person is actually acting in the course of employment. Now it is saying employer shall be liable for wrong committed by employees in course of employment. Another again it says third party should exercise reasonable care to find out whether a person is actually in the course of employment or not. Now Nandan was appointed by Syndicate Bank to collect small savings from its customers spread over in different places on daily basis. Nagma, a housemaid, was one of such customers making use of Nandan's service. Syndicate Bank, after a couple of years, terminated Nandan's service. Nagma, unaware of this fact, was handing over her savings to Nandan, who misappropriated them. Nagma realized this nearly after 3 months when she went to the bank to withdraw money. She filed a complaint against the bank. Okay, now let us see principle A. If Nandan is committing something wrong in the course of employment, this principle 1 will be applied. An employer shall be liable for the wrongs committed by employee in the course of employment. So now employer will be liable if he is acting in the course of employment. But it says Syndicate Bank after a couple of years terminated Nandan's service. So now that means Nandan is no longer a part of the bank. So now third parties must exercise reasonable care. So Nagma is expected to exercise a reasonable care. Okay, now these two principles, let us see what are our options. Possible decision. Syndicate Bank shall be liable to compensate Nagma. May or may not be, let's see. Syndicate Bank shall not be liable. Nagma has to blame herself for her negligence. Now this cannot be the option. Okay. Nandan was not acting in the course of employment because someone has cheated her, so she cannot be blamed for her negligence. Okay. Nandan was not acting in the course of employment after termination of his service. Yes, he was not. A person cannot blame others for his own negligence. Let us see whether this Nagma has been negligent here or not. If she is negligent, then definitely these two principles will be applicable, C and 2. Okay, let us see the other option. Nagma was entitled to be informed by the bank about Nandan. Now, this is a critical thing here. Nagma was entitled to be informed by the bank about Nandan. Now, let us see the case of Nagma. Nagma is a housemaid. She is a housemaid. Bank is entitled to expect its customers to know their actual position. Now, Nagma is a housemaid. She is giving money to the person who is coming on behalf of bank. Now, how Nagma is authorized to know whether Syndicate Bank has terminated Nandan or not? Isn't it the duty of Syndicate Bank to inform Nagma that, see, Nandan used to collect money. Now we have removed the Nandan's contract. You need not pay Nandan anymore. We'll send someone else. Isn't it? Shouldn't this be the position? So bank should have informed Nagma. It is not the negligence of Nagma. It is the negligence of the bank. Okay. So now let us find our decision. So when the bank is negligent, definitely bank will be liable for compensation. So we'll choose Syndicate Bank shall be liable, option A here, and possible reason we'll give it for it is Nagma was entitled to be informed by the bank about Nandan. Okay, so we'll go with combination of A and option 3. Let us see which one gives that. A and option 3. This is C. Okay, so our answer is going to be C. See, we are discussing a lot of stuff here. but you have to keep practicing it. Okay, we cannot devote a lot this kind of time. You cannot devote in your mental activity in a CLAT examination. You are allowed a very less amount of time, just 1 minute or barely less than 1 minute even for one question. And these questions like this, if you start reading it in a detailed manner, start making reasoning then and there only, it will be difficult for you to complete your paper. Okay, so it is advised that you go through this test series and on your own also do a lot of test questions so as to make yourself ingrained and fine tuned with what you may face in the CLAT. 46. A master shall be liable for the fraudulent acts of his servants committed in the course of employment. Principle 1. Whether an act is committed in the course of employment has to be judged in the context of the case. Okay, case to case, it will depend whether the person while acting was in the course of employment or not. Very well, no issues. Both master and third parties must exercise reasonable care in this regard. Master should have a close control over the employees, and third party should also closely deal with the employees. Okay, so now these are three principles. Let us apply them to the facts. Rama Bhai was an uneducated Rama. It should be Rama Bai, then not Bhai. Rama Bai was an uneducated widow, and she opened an SB account with Syndicate Bank with the help of her nephew by name Keshav. Okay, she opened an account with Syndicate Bank with help of her nephew Keshav, who was at the time working as a clerk in the bank. Keshav was working at the clerk in the bank. Keshav used to deposit the money of Rama Bai from the time to time and get the entries done in the passbook. After a year or so, Keshav was dismissed from the service by the bank. Being unaware of the fact, Rama Bai continued to hand over her savings to him and Keshav misappropriated them. Rama Bai realized this only when Keshav disappeared from the scene one day and she sought compensation from the bank. Now she is trying to make Keshav or bank liable for the acts of Keshav. Now you see the principal difference between these two questions, this one and the Nagama and Nandan case. Now Nagama is not known to Nandan. She is dealing with Nandan only in the capacity of as an officer of the bank. But here when we look at the facts of the case, Rama Bai and Keshav, they are aunt and nephew. So when she deals with Keshav, she deals with Keshav not in the capacity of a bank clerk, but she deals with the Keshav in the capacity of her nephew. He may be a clerk in the bank. That's just a coincidence. But ultimately, she is dealing with Keshav through Keshav as she trusts Keshav because being her nephew. So bank does not come into picture here. So how can bank be liable for her personal relations committing fraud upon her? Okay. So now this question is different from the other one. So now let us see the options. Syndicate bank shall be liable to compensate Rama Bai. No, syndicate bank will not be. Syndicate banks shall not be liable to compensate Rama Bai. Now this is the correct option here. Rama Bai cannot blame others for the negligence. This is also a good option, but we have to be most appropriate. Most appropriate is syndicate bank shall not be liable. Then let us see the possible reasons for our reasoning, our decision. Keshav was not an employee of the bank when the fraud was committed. This is not a good law because we have discussed even if he is not the employee and the bank is fault, then he will be liable, then the bank shall be liable. But there is a different case. The bank was not aware of the special arrangement between Rama Bai and Keshav. Now, is bank aware? Nowhere it says that bank was aware. It is the bank's duty to take care of the vulnerable customers. Bank cannot know who is a vulnerable customer. That's a difficult exercise. Even you do not know what is a vulnerable customer. Very difficult word to define. Rama Bai should have checked about Keshav in her own interest. Yes, she should have checked. But this should not be the reason we are talking about liability of the bank. So the appropriate answer is syndicate bank shall not be liable. Why? Because bank was not aware of the special arrangement between Rama Bai and Keshav. So let us see, our answer is B plus 2. So A3, C4, B2. Okay, so we'll go with B2. See, one more thing I'll tell you people, that when I come to these practice classes and I teach you, see, I've been teaching these subjects for a long time, but I teach subjects, okay, But these questions they keep on changing, and they are so puzzling sometimes that even me, when I come to teach you people, I have to prepare myself with these things. Okay, I have to prepare myself. So even a trained lawyer and a trained law teacher has to prepare himself with these things, these issues, these questions. So they may be appearing very simple to you when I'm teaching you, but if you go unprepared in the examination, I'm telling you that you are going to face, worst nightmares in the exam. So don't go unprepared. I'm telling you, me as a teacher, as a trained tutor, as a trained lawyer, has to practice a lot for coming clean with this question. So you, as a student, a budding lawyer, definitely has to devote a lot of time. And Clat is a time-limited exam, and you are not supposed to do only law portion. Law portion is 50 marks. You have GK and mathematics, English, other subjects as well. So you start preparing before the next exam so that you are prepared, because you have to cover not only legal subjects but extra legal subjects as well. Okay. A person is liable for the negligence if he fails to take care of his neighbor's interest. Okay. A neighbor is anyone whose interest should have been foreseeable by a reasonable man while carrying on his activities. Now we have discussed a case like this. Anyone can be a neighbor. Okay, neighbor means not next door neighbor, but anyone who may get affected by your activities will become your neighbor. A cricket match was going on in a closed door stadium. Closed door stadium. A cricket fan who could not get into the stadium was watching the game by climbing up a nearby tree and sitting there. The cricket ball in the course of game went out of the stadium and hit this person and injured him. He filed a suit against the organizers. Now let us see the possible decision. The organizers are liable to compensate this injured person. The organizers, oh sorry, in this case let us go for options first. What are the options? A and 4. Organizer are liable, and what is the reasoning they are giving? The organizer shall be liable for everybody likely to watch the game. See, this cannot be the option. Organizer cannot be liable for everyone who is watching the game. Organizers will be liable only for those who are watching the game within the stadium, not outside the stadium. So option A is out. B, A, organizers are liable to compensate the injured person. Reasoning is 3. A person crazy about something must pay the price for that. Uh, so these two does not go hand in hand together. So this also cannot be the reasoning. Let us see C. Organizers are not liable to compensate the injured person. And 2. The organizers could not have foreseen somebody watching the game by climbing a tree. Now this seems plausible. Now first look at the option D as well. C and 1. C is organizers person should have avoided the place where he might be hit by the cricket ball. The injured person, yes, definitely he should have avoided the place. 1. The organizers are responsible for the people inside the stadium. Now this is also correct answer. Okay, this also correct answer, but we are discussing about whether compensation will be given or not, because he has filed a suit for compensation. Okay, so now we have to decide on compensation. So we'll go with the option. The organizers are not liable for compensate the person. The organizers could not have foreseen somebody watching the game by climbing up a tree. We have to apply the principle whether he becomes a neighbor or not. He is not a neighbor. Okay, neighbor. Who are the neighbor? Neighbor are people inside the stadium. He is far off the stadium, climbing on a tree on his own crazy activity. So he does not become a neighbor. Why he does not become a neighbor? Whose interest should have been foreseeable by a reasonable man. Reasonable man. Stadium people cannot expect people standing, watching match from the trees, and trees are outside the stadium. How can they expect it? Okay, so by that principle, he does not become a neighbor, so they are not liable. So B and 2. Option is C. So our answer is option C here. When a person unlawfully interferes in the chattel means goods. It's an English term for goods. Okay, goods and property of another person, by which the latter is, don't confuse it with cattle. Okay, of another person by which the latter is deprived of its use. The former commits the tort of conversion. Okay, we have discussed this principle. If you are interfering with somebody's possession, ownership, you are committing tort of conversion. That means you are converting the ownership. Okay, nobody shall enrich himself at the other's expense. Okay, nobody should be allowed to enrich himself at the cost of other. A patient suffering from stomach ailment approached a teaching hospital. Okay, a teaching hospital. He was diagnosed as suffering from appendicitis and his appendix was removed. Okay, he was diagnosed as suffering from, he was having appendicitis and his appendix was removed. He became alright. The hospital, however, found some unique cells in the appendix and using the cell lines thereof, it developed drugs of enormous commercial value. When the erstwhile patient came to know of it, he claimed a share in the profit made by the hospital. I understand. I guess you have got the facts. Okay. The hospital need not, now let us see the decision. The hospital need not share its profits with the patient. The hospital may share its profits on ex gratia basis. The hospital shall share its profits with the patient. Ex gratia means honorary basis. Okay, ex gratia means honorary basis. Okay, that means because you have done something for us in the past, so we'll pay you today. So has he? Okay, let us come to the reasoning later on. First, read all the questions. Uh, the patient, far from being deprived of the use of his appendix, actually benefited by its removal. Is this option right? Yes, this option is right. He has actually benefited. He became all right. The hospital, instead of throwing away the appendix, conducted further research on its own, and the development of drug was the result of its own effort. Yes, this is also appropriate. The hospital could not have achieved its success without the appendix belonging to the patient. Okay. Everybody must care for and share with others. Now, this is not an option. Everybody must care and share. This is charity, is not an option here. So, option 4 is out. Now, let us see A and 1. A hospital need not share the profits. 1. The patient, far from being deprived of the use of appendix, actually benefited by its removal. Okay, option. It appeals to me. B. A hospital need not share profit. Why? 2. Hospital, instead of throwing away the appendix, conducted further research on it on its own. Yes, they are working. They have benefited. This is also plausible option. C. Hospital shall share the profit with the patient. Reasoning is the hospital could not have achieved the success with the appendix belonging to the patient. Okay. C. The hospital should share profit for charity. So option D is out. We have now left with three options. Now let us apply. Let us go back to the principle. Principle is talking about conversion interferes with the chattel of another person by which the latter is deprived of its use. So unlawfully interferes with the chattel. Has the hospital unlawfully interfered with the chattel? Yes or not? Has hospital unlawfully removed his appendix? First of all, no. So when hospital has not unlawfully removed the appendix, so definitely hospital need not share its profits with the patient. A is our answer for decisions. Now let us see. A is 1 and A is 2. Now the patient, far from being deprived. Now what should be the reason? The patient, far from being deprived of its use of his appendix, actually benefited by its removal, or instead of throwing away appendix, conducted further research on its own. Okay, now both options appear correct, but let us see. Nobody shall enrich himself at the other's expense. So now we have to see whether hospital enriched himself at the expense of him. Okay, the patient, far from being deprived. Now we have to see whether removal of appendix has actually caused a problem to this person. Okay, or this person has to suffer from the removal of the appendix. Then only we can say nobody shall enrich, that they have enriched at his expense, but he actually benefited by its removal. So the person actually benefited by its removal, so we cannot say hospital did something at the expense of this person. So now we have got our answer. Hospital need not share the profit and the patient far from being deprived. So we'll go with option number A here. See these kind of questions where two or even three options may appear right. Okay, you have to be very critical. You have to see what is the principle and you have to apply the principle. Or principle 1, by applying principle 1 we came to this conclusion. Now by applying principle 2 we find out the reason. If we go with the reason, the hospital, instead of throwing away the appendix, conducted further research on its own and developed the drug. That is talking about the efforts of the hospital, but principle 2 is not talking about efforts anywhere at all. Principle 2 is talking about Nobody shall enrich himself at others expense. Now principle 2 is talking about you are getting profit by somebody else's suffering. We have to see whether other person which reasoning talks about the suffering. So this reasoning is the one which is talking about the suffering. Far from being deprived of the use of appendix, that far from being that rather than being deprived from the use of appendix, he actually benefited for its removal. So he has not suffered, in fact he has gained for the removal. So this principle squarely applies here as our reasoning. By applying both the principles, we have found out our answer. Parliament enacted a law which, according to a group of lawyers, is violating the fundamental rights of traders. A group of lawyers files a writ petition challenging the constitutional validity of the statute, seeking relief to quash the statute and further direct the Parliament to enact a new law. Statute may be a new term for you people. Where is it? Statute. Statute is just another way, like we have so many words in English language. Statute is another term for law. Okay, so whenever you read statute, it means we are talking about the law. So like when I say Indian Penal Code, okay, we have a criminal law. So you can also say Indian Penal Code is a statute. You can say Indian Penal Code is a law. Okay, you can say Indian Penal Code is a code. All these ways refer to law only. So statute is a law only. Need not get confused with these heavy words. Okay, and what is a writ? We have discussed in the constitutional law classes. A writ is that you can go and apply to the court. Okay, in different mandamus, habeas corpus, certiorari, you can challenge the government action through a writ. Okay, you can challenge the action of the government through filing a writ. Okay, those petitions, writs are nothing but petitions which are challenging the action of the government or the authority, public authority. They are known by the writ. Okay, so we call them writs. So because statute or a law is passed by the government, that means they are going to file a petition or a application against the government. So what do we call that application? Legal name for that application is a writ. Okay, so these are just terminologies. Don't get confused by these heavy words. Okay, so now let us see. Someone has government has passed a law and they have filed an application against the law. Let us see. No writ would lie against a parliament, as the court has no authority to direct parliament to enact or reenact a law. Yes, parliament court cannot tell parliament whether to enact or not to enact a law. It is parliament's freedom. Yes, separation of power. The court can quash existing law if it violates fundamental rights and can direct parliament to make a new law. Okay, parliament to make a new law. Okay, court can do that. Court can do. Can court quash an existing? Can court say this law is unreasonable? Yes, court can definitely say. But when we say court cannot direct parliament, so this further says if it violates and can direct parliament to make a new law. Now this line is not digestible. This line is not okay. This answer is right if it was still here, but it goes further, so this option cannot be a good option. This is also not an option because it cannot be say that court cannot challenge the law made by parliament. Okay, yes, court can definitely see the validity of the law. None of these can is rarely an option. Okay, so you forget none of these at any time. The court can quash the existing law if it violates fundamental rights, but cannot direct parliament to make a new law. Yes, this is our answer. So you have to read. See, another key aspect about Clat is that you have to read the principle properly, facts properly, and even your options properly. If you are in a hurry, had I been sitting in the exam right now and I been in the hurry, so I would have just read the court can quash the existing law if it violates fundamental right, and I would have just ticked okay that yes, court can do so, but it would have been a wrong answer. Okay, because the further line says something else, which is not a legal position. So this is how you have to deal with the Clat. When a person signifies to another his willingness to do or abstain from doing anything, with a view to obtaining the assent of that person to such an act or abstinence, he is said to have made a proposal. Okay, now we discussed what a proposal is. When someone makes a offer to someone that if you will do this for me, I will do that for you. If you will do this for me, I will not do that. Okay, either I will do something or either I will abstain from doing something if you do that particular thing or don't do that particular thing. This is the kind of proposal we discussed. Ramanuj telegraphed to Shyam Sundar, writing, will you sell me your Rolls Royce car? Telegram the lowest price. Okay, now we have to see there are two questions. Will you sell me the Rolls Royce car? Question number one. Telegram me the lowest cash price. Question number two. Shyam Sundar also replied by the telegram, lowest price for car is rupees 20 lakh. Okay. Ramanuj immediately sent to his consent through the telegram stating, I agree to buy your car for 20 lakh asked by you. Shyam Sundar refused to sell the car. Now, has here any contract taken place? Has anyone made any offer to someone and has anyone accepted an offer? Now let us see the situation. There are two questions. Will you sell me the Rolls Royce? Question number one. Telegram the lowest cash price. Okay, question number two. Now Shyam Sundar has said lowest cash price is 20 lakh. He has replied for only question number two. Question number one was the offer. Will you sell me the Rolls Royce car? Shyam Sundar, Ramanuj made an offer. Will you sell me the Rolls Royce car? Shyam Sundar has not replied on this question. He has kept silence on question number one, only replied to question number two. Now Ramanuj immediately sent that I agree to buy a car for 20 lakh. Where is the question of agreeing when he has not agreed to sell? So in this case, he cannot refuse to sell the car because the contract has already been made. He can refuse to sell the car because it is only an invitation to offer and not the real offer. It was not valid offer because willingness to enter into contract was absent. Okay, so here if we see these two options both appear okay. Okay, it was not a valid offer because definitely it's not a valid offer. To enter into contract was absent. Willingness to enter into contract was absent because Ramanuj never wanted to enter into contract. But let us see, he can refuse to sell car because it was only invitation to offer and not the real offer. Okay, not the real offer. Now we have to go with the whether an offer has been made here. Okay, whether an offer has been made here. So who will make the offer here? Shyam Sundar made an
It's
offer
9
here.
o'clock.
Ramanuj did not accept it. Okay, so he can refuse to sell the car because it was only invitation to offer and not the real offer. Now when Ramanuj is telling, Shyam Sundar is telling lowest price is this, he is only inviting Ramanuj to enter into contract, but he is not making an offer. It is only an invitation to offer. So appropriate answer would be answer B. Okay, appropriate answer is answer B. Okay, we cannot go with option C here. It was not a valid offer because willingness to enter into contract was absent. Nowhere it is talking about any willingness or not. It is a clear case which is dealing with invitation to offer. We have discussed this case in the classes as well. Okay, so it deals with invitation to offer only scenario. So we'll go with the answer B here. Question 51. A person is said to be of sound mind for the purpose of making a contract if, at the time when he makes it, he is capable of understanding it and forming a rational judgment as to its effect upon his interest. So, we are discussing about sound mind person. You all understand what is a sound mind person? Okay, this is the principle here. Now let's apply the principle. Let's read the facts. Mr. Hacks, who is usually of sound state of mind, but occasionally of unsound state of mind, enters into a contract with Mr. Y when he was of unsound state of mind. Mr. Y, having come to know about this fact afterwards, wants to file a suit against Mr. X. Now, when Mr. Y was unsound, he entered into contract. Mr. X was unsound, he entered into contract with Mr. Y. Mr. Y came to know later that when he entered the contract, he was unsound. So he now wants to file a case. So now can an unsound mind people enter into a contract? We go to the capacity to enter into contract when we discuss contract law. Definitely an unsound mind is incapable to enter into contract. So now keeping this in the background, let's go to the proceed to the options. Mr. X cannot enter into contract because he is of unsound state of mind when he entered into the contract. Mr. X can enter into contract, but the burden on the other party to prove that he was unsound state of mind at the contract. Mr. X can enter contract, but the burden is on Mr. X to prove that he was of sound state of mind. See, why should we go into these options, questions of burden? Who will prove what? Who will prove what? Straight away, we'll apply the principle to the fact. Mr. X cannot enter into contract. He is of unsound mind. That's it. Clear. There's no burden, nothing else. Okay. So only thing asked is whether applying this principle, what comes to your mind first and most appropriate. This is state of mind. Okay, Mr. X Can enter into contract, he can not enter into contract. Okay, these all options are gone. Willful rash driving is an offense. Mr. Tiwari was driving his car after drinking alcohol. Police books him for willful negligent driving. Is the act of police lawful? No, because Mr. Tiwari was not driving rashly, he was drunk while driving. No, this is not a negligent act. Yes, because Mr. Tiwari was driving rashly. Yes, because police has power to arrest person driving rationally. Okay, now rashly. Now, what police has done? Police books him. Books him means police files a case. Police is nowhere we are talking about arrest. So option D, yes, because police has a power to arrest. We are not talking about arrest here, so this cannot be an option. So definitely, when someone is driving rashly and under the influence of alcohol, police will file a case. So all options going with the no are not correct options. So only option left is yes, because Mr. Tiwari was driving rashly. That's it. Willful rash driving is an offense. He is driving in the alcohol. Police files a case. Yes, because Mr. Tiwari was driving rashly. Act of police lawful. Yes. So we'll go with this option. Question 55. Mere silence as to the facts likely to affect the willingness of a person to enter into a contract is not a fraud. Mere silence is not a fraud, we discussed, unless the circumstances of the case are such that on close examination it is found to be the duty of the person keeping silent to speak. On close examination it is found that he should have spoken. In that case, we'll treat silence itself as a fraud. Okay. Unless his silence is in itself equivalent to speech, or his silence is equal to speech. Okay, mere silence on the facts which are likely to affect someone else's willingness, mere silence is not an offense. Okay, but unless his silence amounts to speech or where he has a duty to speak. X sells by an auction to Y a horse which X knows to be of unsound mind. X says nothing to Y about the horse's unsound state of mind. Give the correct answer. Okay, X can be held liable for the fraud. X can be held liable for the misrepresentation. X cannot be held liable because he did not say anything positive about the mental state of the horse. X cannot be held liable because it's the buyer who must be aware of the thing. Now, in this question, if it could have said that X asked Y whether horse is of sound mind and Y remained silent, then X could have been made. If Y asked him and he remained silent, then he would have been liable. But here he is just selling a horse. What he's selling? He's selling a horse only. Okay, and he's purchasing a horse. Now, whether horse is of sound mind or not, he has to ask him. But if he did not ask, he did not tell. Okay, so in this case, our option is answer C. X cannot be held liable because he did not say anything positive about the mental state of horse. Okay, when he has not said anything positive at all. See, now you people must be wondering that this person has definitely done something wrong. Now, why we are not making him a guilty party? Because selling a horse has to be of sound mind. But let us see the options. X can be held liable for fraud. When we discussed fraud, fraud means actively making a statement which you do not believe to be true. So here, in the fact, he has not made any such statement. Okay, misrepresentation. Again, when you are giving misleading things, so he is not misleading at all anything. He's just saying I am selling a horse. That's it. He's not saying I'm selling a healthy horse, sound mind horse, and this and that. Okay, so in the facts, nowhere it is shown that he has committed fraud or misrepresentation. So we'll go with this option. Okay. Otherwise, in the practical sense, he may be guilty, but we have to remain bound to the question. Okay. Don't let your emotions enter into it. Okay. Don't compare it with the practical situation. Practical situation, anything may happen in the law. No, nobody knows it. Okay. Now from 56 to 63, we have to talk about, we have to deal with questions which have an assertion and then reasoning, and we have to decide whether assertion and reasoning are right or not, and whether they are correct explanation of it or not. Okay. Assertion is avoid contract is necessarily illegal. That avoid contract is necessarily illegal. Reason every legal contract is void. Every legal contract is void. Let us see. Now, is this statement true? Avoid contract is necessarily illegal. Is this statement true? Sorry, avoid contract is not necessarily illegal. Yes, now this statement is true. I had missed the word not. I was thinking avoid contract is definitely avoid contract can be a civil contract as well, may not be illegal all the time. Every legal contract is void. Yes, illegal contracts are all void. But is this the correct explanation of is are the correct reasoning behind A? Okay. No, R is not the correct reasoning behind A. Okay, because void contract is a bigger term than only mere illegal contract. Okay, so it's a bigger term, it deals with different classes as well. Illegal contract is a very short term, so it cannot be a perfect explanation for it. So we'll go with both A and R are individually true, but R is not the correct explanation of A. Okay, R is not the correct explanation of A. The state shall not make any law which takes away or abridges the rights conferred by Part 3, that is, fundamental rights, and any law made in contravention of this clause to the extent of contravention shall be void. This is the principle that state shall not make any law which violates or takes away fundamental rights of the citizens. Okay, and whatever portion takes away the fundamental rights of the citizens shall be declared unlawful, and whatever portion is okay shall stay okay. Okay, the fundamental rights are the rights reserved by the people, and for this reason they are eternal and sacrosanct. So they both are correct explanation of each other. Okay, state cannot make law, and whatever make the law against fundamental rights, this shall be unlawful. Why it shall be unlawful? Because fundamental rights are reserved for the people, and for this reason they are eternal and sacrosanct. Yes, so we can go with happily say both A and R are individually true, and R is the correct explanation of A. So we'll go with answer A. Need not bother about another options. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Okay. Institutions established by the minorities are not entitled to government aid, and government is not under an obligation to give aid. Now, this statement is true, but it cannot be said that institutions established by minorities are not entitled to government aid, because government cannot discriminate on the basis of religion or minority status. So if government is providing aid, government will provide aid to minority institutions as well. So R becomes wrong here. R becomes wrong here, but A is true. So we'll go with option A is true, but R is false, because R statement is false. X, because of unsound state of mind and not knowing the nature of act, attacks Y. Okay, X, who is of unsound state of mind and not knowing nature of his act, attacks Y. Who in self-defense, Y, in self-defense and in order to ward off the attack, hits him, thereby injuring. Y has not committed an offense. Yes, Y has not committed no offense here. Y had a right to private defense against X under section 98 of Indian Penal Code. So yes, definitely Y has not committed an offense. And who says, how do we know that Y has not committed offense? This is by section 98 of IPC. We read it. Okay. So yes, both A and R are true, and both correct explanation as well. So we'll go with option number A. Need not ponder over another options here. The essence of joint liability under section 149 of IPC is that the criminal act must have been done with a view to fulfill the common object of an unlawful assembly. We have discussed this unlawful assembly situation. Okay, rights. Okay, writing is an unlawful assembly situation. So the essence of joint liability under section 149 is that criminal act must have been done with view to fulfill common object. They have a common object. Okay, any sudden and provocative act done by a member of an unlawful assembly would render the other members of that assembly liable. Okay, so yes, when we talk about riots, okay, people like 20, 40 people are going in the road, they are chanting against the government, they are breaking the buildings. If some of them does have a revolver and he kills someone, then the whole assembly will jointly be liable. Okay, the whole assembly will jointly be liable because they have a common object of creating anarchy. So creating anarchy, whatever they do, they break buildings, they burn cars, or they kill people or beat people, everyone would be liable because assembly gives strength. This person otherwise would not have killed someone, but he thought that I have a lot of crowd with me, so in the shield of crowd he committed the offense. So this crowd gave strength to happening of an offense. This crowd becomes a consequence for happening an offense. So this crowd shall be liable for this. So A and R are individually true, and R is correct explanation of A. The Indian Constitution was adopted on 26 November 1949. The Law Day is celebrated in India on 26 November every year. Okay, so Indian Constitution, like we discussed, was adopted on 26 November 1949. Now you don't get confused. We adopted Indian Constitution on 26 November 1949, but we enacted it on 26th of January 1950. So both things are different. Okay, so in this case, you don't have to simply say no, 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 this cannot be right. We got it on 26th of January. Okay, we discussed in the Constitution class that it was adopted on 26th November, but enacted, it became operative only on 26th of January. So yes, this is correct statement. Law Day is celebrated in India on 26th November every year. This is also a correct statement. But to say that Law Day is celebrated only because Constitution came in that day will not be a correct explanation. Why? Because law was prevalent even before the Constitution. Constitution came in 1950. We got separation in 47. So 47 to 50 for 3 years as well we had law, and prior to that as well we had law. So law did not come on 26 November 1949. Constitution came. So if the reason would have been Constitution Day, Law Day, now it is called Constitution Day as well. Some people call it Law Day, some people call it Constitution Day. So if the question R was Constitution Day celebrated so and so, then it would have been correct explanation. But right now both are individually true, but both are not the correct explanation of each other. So here we'll go with option B. In the event of violation of an illegal right, tort, the aggrieved party is entitled to recover unliquidated damages. Okay, if there's a violation of an illegal right, the aggrieved party is entitled to recover unliquidated damages. We discussed unliquidated damages means not pre-decided damages, which means damages which will depend upon the happening, how much injury, in what manner it has happened, and all the issues. The object of awarding damage to the aggrieved party is to put him in the same position in which he would have been if the wrong would not have been committed. Damages are therefore assessed on that basis. So now it is true, and this statement is correct, and this statement is also correct. Like I said, damages are to be assessed on the case to case basis. So A is correct, R is correct, and R is true explanation of principle A. So we'll go with option A here. A person claims compensation for non-gratuitous act. Non-gratuitous act, gratuitous, you can simply say done for free. So non-gratuitous. Means not done for free. Okay. A person claims compensation for his non-gratuitous act. Yes, definitely he'll claim compensation for something which he is not doing freely. A person who enjoys benefit from the lawful non-gratuitous act of another must compensate him even though there is no contract. Okay, even though there is no contract. Now let us see. Both A and R are individually true. Yes, both the statements are true. And R is correct explanation of A. Let us see whether R is correct explanation of A or not. A says a person claims compensation for his non-gratuitous act. Okay, it is talking about person claiming compensation. A person who enjoys from lawful non-gratuitous act of another must compensate him even though there is no contract. This statement is also true. Uh, but this is not explanation for this. Okay, this is not the correct explanation for this. If both statements are true, correct explanation for this would have been giving reason why he is to be compensated, that he has enjoyed some benefit and he has done some act and this like this. This is principle, okay, correct. This is also a principle which is correct. Both are good principles, but they are not explanatory of each other. So we'll go with option B here. Okay, so see, these are very tricky questions. These are googly questions. So exercise as many of them as possible, okay, in order to succeed in the exam. Otherwise it's a tough exam, I'm telling you. You may even call it one of the toughest exams in India. The following are enshrined in the preamble of the Constitution of India. Now we have done preamble of the Constitution of India. Equality of status and of opportunity, liberty of thought, expression, belief, faith, worship, yes. Justice, social, economic and political, yes. Fraternity, assuring the dignity of individual, yes. Unity and the integrity of the nation, yes. They all are right. Now what is the question? Let us see. Okay, they are asking about correct order in which they appear in the preamble. We have to find out the correct order. Let us see. uh, so one thing you have to always remember. So I tell you a keyword here. This is the formula. You have to remember this word. Whatever message you can expand it to into, or whatever you can do it. But this kind of question often asked, and people are confused there because all the principles to finding the correct order. You just remember JELUF. That means justice, equality, liberty, unity, and fraternity. Okay, this is the correct order. JELUF you have to remember. Now you can make a story over it so as to memorize it. You can make personal examples with this, but I am giving you JELUF, or you can just simply remember JELUF. Okay, it will begin with J, it will end with an F. Okay, it will begin with J, it will end with F. So now we have B, justice, equality, justice, liberty, equality, justice, liberty, equality, fraternity, and unity. Oh, sorry, I have given you a wrong principle. Let me correct myself. I'm myself confused here. It has to be somewhere justice. Then there will be, yes, justice, then liberty, then equality, then comes fraternity, and then unity. So I have written. Sorry, I'm really sorry. So justice, JLE, justice, liberty, equality, then the word used is fraternity. J L E F U. J L E F U is the correct order. Justice, liberty, equality, fraternity, and unity. I'm really sorry, these questions are very confusing, so you have to practice them. See, I just told you that even seasoned lawyer like me or any other person, we do also go wrong in these kind of questions many times. So see how much practice you people will have to put in. Identify the correct statement. You have to identify which statement is correct. Federalism implies a system of government which embodies a division of powers between a central and a number of regional authorities. Okay. Federalism implies a system of government which embodies a division of powers between legislature, executive, and judiciary. This statement is true, but this statement does not deal with the federalism. It deals with the separation of power between the wings of the government. So these are three wings of the government. We call it separation of power (SOP) theory. Federalism implies a system of government which embodies parliamentary supremacy. This is called a parliamentary supremacy theory only. This is not called federal theory. So none of these is not an option. So only option available is A, which says federal is a system of government which embodies division of power between center and state. So division between Union of India and the State of India. So this is the correct option to choose here. Okay, so now enough for today's class. We'll meet in the next class. I'm really sorry for going wrong here, but yes, that's all human. I hope you'll understand.